consider today myself to be one of the privileged person for giving me a chance.
Please, please order.
For giving me a chance by the Deputy Speaker and my leader Mamata Banerjee to speak on this subject itself. Sir,
that is next time that
what
will
is
be the
happening,
sir.
please? Sir,
It's showing the indication
if
of next year.
it is
Yes, okay.
Please order.
sir,
please,
if it
please
is
order.
considered in the world that Lord Denning is the best judge in the world itself, in our country, Dr. Ambedka was and is still the best jurist of the country. Dr. Ambedkar was an illustrious leader. He was the chief architect of the Indian Constitution. A good and virtuous constitutionalism having moral foundation protects not only fundamental freedom and rights, but also creates a bridge between conflicting interests and becomes a harbinger to the social needs and produced good legislatures and good citizens. The constitutional courts as sentinel on the quagmire therefore functions objectively and dispassionately to correct imbalances and keep check on every wing of the state without trespassing upon the field assigned or powers conferred upon the other wings, and at the same time maintain a delicate balance. A constitution is the documentation of the founding faiths of a nation and the fundamental directions for their fulfillment. The written constitution of a country is the document which defines the regular form or system of the government, containing the rules that directly or indirectly affect the distribution exercise of the sovereign power of the state, and it is thus mainly concerned with the creation of the three organs, that is the executive, the legislatures, and the judiciary, and the distribution of the governmental power among them and the definition of their mutual relation. And we have to work in letter and spirit of the Constitution itself. The founding father of the Constitution, cognizant of the reality of life, wisely engrafted the fundamental right and directive principles in Part 3 and 4 of our democracy of life to everyone in Bharat Republic. The significance of the perception that Parts 3 and 4 together constitute the core of commitment to social revolution of the society, and they together are the conscience of the Constitution and is a deep understanding of the Indian Constitution itself. Sir, India is a secular country. Secularism has been inserted in the preamble by reason of the Constitution Amendment, 42nd Amendment of 1976. The object of insertion in the said word was to spell out expressly the high ideas of the secularism and the integrity of the nation. Secularism does not mean the constitution of the theocratic society. It merely means equal status of all religions without any preference in favor of or discrimination any of them. It is clear from the constitutional scheme that it guarantees equality in the matter of religion to all individuals and groups irrespective of their faith. Emphasis in that there is no religion of the state. Preamble of the Constitution, read with particularly Article 25 to 28, indicates that the concept of secularism is embodied in the Constitution scheme itself. Article 29 of the Constitution speaks of protection of interests of minorities. Article 30 speaks of right of minorities to establish an administration educational institution. Please, excuse me, sir.
Please.
Sir, the concept of secularism is one facet of the right. to equality woven as central golden thread in the fabric depicting the pattern of the scheme of our Constitution. Secularism is a given. Pride of place in the Constitution itself, sir. Dr. Ambedka said, quote, "I like the religion that teaches liberty, equality and fraternity," unquote. Dr. Ambedka said, quote, "Religion is for man and man for not man for religion," unquote. Dr. Ambedkar said, quote, "The basic idea underlying the religion is to create an atmosphere for the spiritual development of the individual," unquote. Our Constitution has secured independence to the judiciary and jealously guarded the independence of the judiciary. Independence of judiciary is doubtless a basic structure of the Constitution. But the said concept of independence has to be confined within the four corners of the Constitution and cannot go beyond the Constitution. Our Constitution is liberal, democratic, egalitarian, secular, and federal in character. Dr. Ambedkar said, quote, "Our object in framing the Constitution is twofold: to lay down the form of political democracy and to lay down the idea of economic democracy, and also to prescribe that every government, whatever is power, which shall strive to bring about economic democracy," unquote. Since our Constitution is federal in character, likewise central government, every state government are also elected by the people. Relations between the Union and the states have been engrafted under Part 11 of the Constitution. Power of enactment of laws made by the Parliament and the legislature of the states has been provided under Article 226 of the Constitution. Our Constitution does not permit the central government to interfere with the state subjects and thereby any attempt to destroy the federal character of the Constitution. Recently, Government of India has issued a directive that all central schemes will be monitored by a Deputy Secretary level officers of the Government of India. These officers, as a part of overseeing the central schemes, will travel to different states to monitor the progress of the scheme on the ground. This move of the Government of India tantamounts to mistrust of the official machinery of the state government. As is the present practice, all schemes under the state plan, including centrally sponsored schemes, are implemented and monitored by the state machinery. The Government of India releases the fund to the state government on the basis of physical and financial progress of the scheme, and after due submissions of this utilization certificate by the state government. This system has been in vogue since the introduction of the central schemes and is functioning well. The new system will severely impact the autonomy of the state government and is against the spirit of the cooperative federalism. Sir, Dr. Ambedkar fought for the protection and reservation of the scheduled caste and scheduled tribes. Now attempt is made to take away such protection and reservation. Sir, it is surprising that the Honorable Prime Minister and other ministers holding video conference with the Chief Secretary under the guise of development, knowing development programs. This amounts to direct interference with the state administration. If the Honorable Prime Minister and any of the ministers wishes to know the development of the state itself, he is free to talk with the Chief Minister.
That's correct, yes.
Sir, nobody should think, with great respect to the Honorable Prime Minister, I am saying today, please do not take me amiss. With great respect, I am saying, like the Honorable Prime Minister, all the Chief Ministers of the country are also good administrators. They are also the honest persons.
Unlike.
They are also political persons. They have fought for 30 years, 40 years, 50 years in the field. They have not been sent to the state as a chief minister from Delhi office for running the state itself. It's with great respect I am saying. Don't undermine any ministry, chief ministers. Don't undermine any state governments. Sir, law and order is the state subject. The government of India has taken up the plan scheme aimed at creating a comprehensive and integrated system for enhancing the efficiency and effectiveness of policing and creation of an IT-enabled state-of-the-art tracking system and around investigation of crime and detection of criminals. The ostensible objective of the program to improve police functioning in various areas such as law and order, traffic management, and what is being done? Under the guise of this, every case has to be reported. And from Delhi, in the Home Ministry will monitoring all the law and order cases which are registered under the state, which are under the subject matter of the state law and order. Sir, does it not betray the cooperative federal system of the country? What you are trying to achieve, which you cannot achieve under our constitutions, you are trying to achieve, the central government is trying to achieve in an indirect method for the purpose of keeping record and indirectly monitoring the cases. This is not permissible under the constitution itself. Sir, IAS officer and IPS officers of the state cadres, they are sent here for training for 2 years. After the 2 years, these officers are required to be sent to the state. My question today is, why? After this training, why you are keeping these officers in your Delhi ministry under the various ministry? For what purposes? Our Union Ministry Delhi being under the different ministries? Under what law? Under what provisions? Can I ask the question? Are you trying to brainwashing the brain of the IAS and IPS officers before sending them to the state? Under what constitutional provisions these things can be done by the Honorable Prime Ministers and the other ministers? The center during the current financial year has unilaterally restructured a large number of centrally sponsored schemes without consulting the state governments. State governments' ratios has been decreased. I fully support my other friend just now has said from the AIDMK. Really, in a case of a concurrent list, if a law has to be legislated, why you are not consulting the state government itself? It cannot be an idea and concept of only the central government. A concurrent list is no doubt for the state and the central government. No doubt the central government is having a power. Do not try to be the big brother of the country itself. All are not small. Because of this, yes, very big brother or elder brother, whatever you say, elder brother of the country. This is a said. Under our constitutional scheme itself, state government is not the junior of the central government at all. Likewise, the central government independency, state government is having his own independency. Nobody is under any control. But scheme is there, relationships is there, which I have referred to, part 11 of the Constitution itself. The central proceeds on accounts of collection of cess and surcharges do not form part of the divisible pool of central taxes shared with the states. The shares of cess and surcharge in gross tax revenues of central government over a period of time has substantially increased from 3.51% in 2001 to about 9% in 2015 to 16. These states have been demanding the proceeds on account of cess and surcharge should be shared with the states. The government of India has not acceded to this demand. Instead, recently, despite of sluggish economy and challenges being faced by the country and the states to spur economic growth, this center has imposed 0.5% cess on service tax for its Swachh Bharat program. States were not taken into confidence while imposing this burden on the common man and economy. This is against the spirit of the cooperative federalism. The non-tax receipts of the central government have steadily grown by 11% over the last decade. A substantial amount of non-tax receipt is accruing from auctioning of license fees and disinvestment in the central PSUs. While the states have equal claim on the proceeds accruing from auctioning of license fees for exploitation of natural resources, it also has a major role in the development of the central PSUs, which are located in the states. As such, the center should share part of the proceeds to the state government itself. Sir, Interstate Council is a constitutional entity created under Article 263 of the Constitution. Although constitutionally mandated, these councils are virtually inactive. A large number of regional issues which could have been easily discussed and resolved in these councils either lie unattended and allowed to assume serious proportions or prompt central interventions. Both these situations are undesirable in a federal setup like ours. Therefore, interstate councils should strengthen and made effective. The centre has passed central legislation and in many areas which overlap with the state governments. The burden of implementing the central legislation like Right to Education Act 2010 and National Food Security Act, which are often passed without any effective consultation with the state government, falls on the state governments. This legislation put enormous financial burden on the state government and forces the state governments to redefine its development priorities in order to provide necessary financial allocation for the statutory liabilities arising out of the Act. Constitution itself envisages planning commission. It was really a concept of Netaji Subhash Chandra Bose. Now Niti Aayog has been substituted, but no plan size has yet been informed to anyone. Sir, in Niti Aayog, not a single discussion has been made by the Honorable Prime Minister accepting the land bill. What is being done by the Niti Aayog? Planning Commission has gone 6 months, no work, even by the Niti Aayog itself. Sir, in recent days, a few governors, sir, you know, governor cannot act without the advice and consultation with the minister itself. In a very recent days, few governors have been appointed. What they are doing, these governors without consulting the state government, these chief ministers and the cabinets, asking for security to the political party's leader. I do not want to name that political party. This government, these governors sometimes, when such political parties' leaders are coming, without asking the chief minister, without consulting anything, asking for CRPF for holding local municipality election. Is it not a breach on the part of the governor? It is not a contravention of a constitutional mandate. Sir, in the Constituent Assembly debates, just 3 minutes, in the Constituent Assembly debates, volume 10, at page 975, it has been recorded, quote, however a good constitution may be, it is sure to turn out bad, because those who are called to work it may turn out to be good if those who are called to work it happen to be a good lot. The working of the Constitution does not depend wholly upon the nature of the Constitution. The Constitution can provide only the organs of the state, such as legislature, the executive and the judiciary. The factors on which the working of those organs of the state depends are the people and those political parties they will set up as their instrument to carry their wishes and their politics. It is therefore futile to pass any judgment upon Constitution without reference to the part which the people and their parties are likely to pay, unquote. Sir, Mother Teresa said, quote, God has not called me to be successful, but God has called me to be faithful, unquote. Therefore, the three organs of the state should be first faithful to the Constitution and discharge their constitutional duties. This is not the time that during 65 years how much successful we are. It is the time to give us answer how much faithful we are to the Constitution itself. Sir, I will conclude it only by saying, today's debates are going on, discussions are going on. Good leaders, speakers, everything have been said. Sir, I will say only with these words, only if we really faithful to the Constitution, all the organs of these countries, either states or judiciary or executive or the people of this country itself, if they are faithful to the Constitution itself, really we will pay respect to Dr. Ambedka and the great leaders. Who are the instrumental, sir? Sir, who are the instrumental to make our country as the largest democratic country in this world itself? With this, I pay respect on behalf of my party, on behalf of my leader, Kalyan Banerjee. Sir, I pay respect to Dr. Ambedkar and all the leaders. And only with a prayer today in this house itself, I am praying, I am concluding it, not today, in the future also. Let us take a promise that we should be faithful to the Constitution itself.
Okay.